Hi everyone, I'm Dale Smith, aka Journo Dale, and we're here to talk about Canadian politics. This week, I thought we'd talk a little bit about the Federal Court of Appeal decision around the Trans Mountain Pipeline last week. So, backstory here is that sometime last year, the Federal Court of Appeal ruled that the approval for the pipeline was rescinded because they hadn't done enough proper environmental assessment and they hadn't done enough consultation with the Indigenous communities that are affected, which is a constitutional obligation. So the government decided rather than appeal that decision, they would simply fulfill the requirements that the Federal Court of Appeal said were lacking, and they went ahead and did that and then reapproved the pipeline a few months ago. After that, about 12 different groups decided they were going to appeal that reapproval and submit it to what's known as judicial review. And judicial review it's sort of an appeal, but what it's basically doing is asking the court to review the decision of an independent body like the National Energy Board in this case, which does the certification. Cabinet still has a sign-off on these projects, but it's how judicial review tends to work here. So what happened last week is that the Federal Court of Appeal said that 6 of the 12 attempts at judicial review would be granted leave. And what that means is that the court will actually hear their argument. The other 6 they decided were without merit, so they were dismissed. And now that means that there's going to be a trial process for those remaining 6, and they're all pretty much narrowly focused on the question of adequate consultation with the affected First Nations. The other interesting portion of this was that the court decided that this would be an expedited process. So any of the materials that they were going to file to challenge the decision would have to be made within the next week, essentially, and they would do a quick hearing process. And what's notable as well is that there was no injunction filed. So that means that construction can still carry on in the meantime because the company is essentially ramping up to do construction now, hiring people and so on. So in response to this, we saw a lot of really hyperbolic statements from both sides. The First Nations groups were saying this was a major court victory, but it's not. It's leave to appeal. This basically is the very low bar that the court thinks that you might have something to say that will be of interest, so they will go and hear it. That's not a major victory in any way. It's just saying that you will have your day in court. The decision around the leave, which was written, which was actually a rare thing, was also to remind them that, duty to consult is not a veto. And so it's setting up the expectation here that they are not going to necessarily be given any kind of veto over this process, that duty to consult is a somewhat narrow issue to be discussed here. On the other side, we heard proponents of the pipeline decrying that this was going to be another delay, which if there's no injunction, there's not really any delay. But we also heard this kind of bizarre argument that the government had just rolled over on this because they didn't file anything challenging the leaves to appeal. And I think that is also not only hyperbolic, but actually wrong, because once again, this isn't much of a process. It's a low bar to establish that there may be an issue worth hearing in court. The government's essential argument is that we fulfilled the requirements of the Federal Court of Appeal's previous decision. They even got a former Supreme Court of Canada justice to walk them through that process, and therefore it's, they basically said we've done what was asked of us. And I can see the argument for them not really looking to file a lot of materials in order to basically draw the process out. So what this means going forward basically is that there will be this hearing within the next few weeks, which is very short time for a court process in this country. And at that point, the panel of the Federal Court of Appeal will decide if the government did indeed meet the obligations that were set out for them in the previous decision that had overturned the approval. So it's going to be a very focused and it's going to be a very narrow decision. And all of this talk about, major victories on one side or rolling over on the other, they just don't hold water. And I think we just kind of need to keep this in mind because we're going to hear all kinds of rhetoric about this. A lot of the stuff coming out in the coming election is going to be around the question of pipelines, and TMX being a particular flashpoint because the environmental side of it is lambasting the government for buying the pipeline and making sure that it goes through. The oil or pro-oil side of it is basically saying we should have a lot more and this government should have approved a lot more. Never mind that the economics of most of these other projects weren't actually sound. So yeah, that's kind of the situation here. Expect some drama, expect a lot more pearl clutching and fainting couches, and most of it will be for naught. And that's everything for this week. Join us again next week for some more Canadian politics. I'm Dale Smith. That's at journo_Dale on Twitter. And don't forget to like the video, share, subscribe, and support us on Patreon. Thanks, everyone.